Good morning, good morning, good morning. Merry Christmas, Merry Christmas, Merry Christmas. It's coming quick, it's coming quick. We'll say Happy Hanukkah as well. Happy holidays to everyone out there. I hope you're all enjoying yourselves. Excited for the holidays, time with family, and gifts and giving and love. And most importantly, Jesus. Baby Jesus' birthday is on Christmas Day, December 25th. That's why we celebrate Christmas. We don't celebrate Christmas for Santa Claus. We don't celebrate Christmas for gifts. We don't celebrate Christmas for love. We celebrate Christmas for Jesus. Jesus Christ was born on December 25th. That's his birthday. That's why we celebrate Christmas. Not what the government has taught us to believe and understand as Christmas. And Coca-Cola has taught us to believe as Christmas, and Santa Claus, red and white. That's not Christmas. Christmas is about Jesus. So let's get into courtroom chaos. Check it out. We're going to start doing this a little more often. See how this does. All right, let's get into it. We're checking out Judge Simpson.
Thank you.
Thank you, Mr. Ryans.
Thank you.
Court does call the case. People versus Brendan Williams.
Hello.
There he is. Assistant Public Defender Natalie Pate with on behalf of Mr. Brendan Williams. Sir, can you please state your full name for the court?
Brendan John Williams.
Thank you. Your Honor, the date and time set for sentencing. Likewise, I had the opportunity to review both the assessment as well as the recommendation from probation. As to the recommendation, we are respectfully requesting that the court adopt it.
Sir, is there anything you? Oh, Ms. Blair.
Correct. Teresa Blair on behalf of probation. I would just like to make the court aware, I did receive Mr. Williams's victims impact panel attendance. Also, so the court is aware, Mr. Williams is already on probation with me on another matter. This case is not a violation of that case. It happens prior to being sentenced.
Got it. All right, Mr. Williams, anything you want to tell me before I impose sentence?
No, thanks.
Okay. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of substance abuse and mental health treatment. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court, I'm going to place you on 24 months probation. You're to pay $1,055 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs. I will waive the probation oversight fees. When can you get that paid, young man?
I was wondering if I can work out a payment plan with my probation officer.
Is he already on a payment plan?
Yes, Your Honor.
All right. There'll be a payment plan as directed by probation. Understand that?
Yep.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a dual diagnosis programming, including all recommended aftercare with status reports to probation. You're to provide proof of the victim's impact panel attendance to probation, which is completed. I'll order 365 days in jail, credit 42. The balance is suspended. Right. Thank you, sir.
Thank you.
Thanks, Mr. Williams.
What? You're messing up my holiday.
I know.
What? No, you stay here. I'm going to go home. You want me to recall both? Is everybody here now? Because everybody like bolted before I came in. I know. I see you. You see that? I was asking you and he just decided to talk. Court calls the case, People versus Jason Eckel. Should have heard. I know you're ready. You should have heard what your client said. I don't know why he's not here. It was horrible.
Good morning, Your Honor. Robert Goldman, P81222, here on behalf and alongside Jason Eckel, president of the courtroom this morning. Mr. Eckel, would you please say your full name for the record?
Jason Michael Eckel.
All right. Thank you. All right. What are we doing today?
Your Honor, this is a date and time set for a sentencing hearing in this matter. I've had an opportunity to speak with the probation department in this case. Your Honor, a plea was conditioned on Mr. Eckel being admitted into the sobriety court. Mr. Eckel did screen with this court's probation department. Ultimately, on Friday, we were advised that he was not accepted into this court's probation sobriety court program. However, having spoken with Ms. Pilara, it is the understanding of the parties that we would be asking for an adjournment today for purposes of screening with the either 15th District Court or another Washtenaw County District Court for purposes of admission. We do think that Mr. Eckel is a good candidate and can be admitted. So for that reason, we are still seeking admission, as we believe that the ultimate benefit of the program warrants seeking an adjournment at this time.
Is that correct, Ms. Pilara?
Yes, Your Honor. I did learn on Friday from the 14A sobriety court that he was not accepted. I did speak with counsel and indicated to him that there is 2 other options in the county that he could try to get into their program. I know that Mr. Eckel did have a couple of appointments in those with ours, and they kind of got bumped down the line. This is why it had to be adjourned. My concern is, and speaking with counsel, this plea was taken with the agreement, is how I read it, that it's kind of contingent upon him participating in the sobriety court. So I would like the court to give this defendant the ability to try to get into one. He did follow through with the screening process. Any delay in that fashion was not on the defendant.
Okay, and I would just indicate, because people have said it different ways, I don't read the plea form that his plea was contingent upon
Okay.
that. What it was is the defendant pled and agreed to enter into the participating in the sobriety court. So I don't think it would be a failure of the plea if he's not accepted.
Okay.
Okay, because I think if it were conditioned on that, that would be something different. But I don't read this as saying that he's just agreeing to go in. If they say no, then we've got to figure out something else to do. But all right. November 16th, December 6th, December 7th. What happened with your testing?
Your Honor, having spoken at length with Mr. Eckel regarding it, those 3 dates, if you notice the times specifically for those 3 out of his windows of the day total, they all occurred when Mr. Eckel was at work. Mr. Eckel does work within the engineering maintenance department of a hotel. The windows that he was just slightly delayed from submitting his test within occurred during times where he was engaged physically in his work. He did then go get his device immediately as soon as he was available. I think his tests are all within 10 to 15 or so minutes of that. We have spoken regarding the need to ensure that it is timely, not just submitted at the about the window. Fortunately, the tests all do come back as negative to verify that he was not consuming. We have spoken. He is going to make additional efforts. For the court's understanding too, I think it's important, as Mr. Eckel advised me, within where he works, there's not a locker or a safe storage area where he can keep his device free from access to others or tampering. So he does have to keep his device in his vehicle. So as soon as he completed an assignment he was working on, he'd go get it, albeit as the court can see, about 10 or 15 minutes after the window closed.
Well, no, it's not 10 or 15 minutes. He was half an hour late.
Oh, I'm sorry.
Yeah, it's okay. Same point. I get it. All right. All right. Just try to make sure you do it within those windows. Okay. The defendant is to seek an alternative sobriety court, either 14B or 15th, which may be available. You live in Ipsy though, so maybe 14B might be a shot he could take.
Yeah, we were going to kind of explore both simultaneously. He does work in Ann Arbor, very close to the 15th District Court. So we were thinking that for review hearings, that might be even more accommodating with his schedule to ensure he can maintain employment and his obligations under the program. We were going to be speaking with both of the courts to help determine which is the most appropriate.
Okay. I'm just thinking as the new sobriety court came in that, well, anyway. I'm going to adjourn the defendant sentencing to January 28, 2026 at 12 p.m.
Thank you, Your Honor.
Okay, all right, thank you. How are you, sir? Yes.
Thank you, Your Honor.
Court recalls case people versus Reginald Sims.
Good morning, Your Honor. Justin Zade appearing on behalf of Mr. Sims. Present standing to my right. State your name.
Reginald Sims.
Your Honor, date and time set for sentencing. We did have an opportunity to review the report. We believe it to be factually accurate. No additions, corrections, deletions. If I just may allocate on my client's behalf.
Yeah, you may.
I know that based on your tone, I think that I think you know what we need, what else we need to address.
Yeah,
If you would prefer that we address the bond violations
we
first.
might need to.
Okay.
do that, but
Certainly.
either way, whatever. your pleasure.
Well, we could start with that. That's fine. We were given the bond violation report. I did have an opportunity to review with Mr. Sims. We went one by one, Your Honor. I understand that the court might have concerns. That looks as though there's some type of pattern of disregard for this timing. And what we would submit to the court is that Mr. Sims has been on this device for about 4 months now, about 120 days, testing 3 times a day. I'm no mathematician, but over 360 tests, I believe. What you see in front of you, I believe, is the extent of the late tests. I believe that there are several late tests, some of which are right outside the window, some a bit delayed. Of course, there's no excuse, no justification for it, but to provide a little bit of context, Mr. Sims works overnights. He works at Ford. And so those tests primarily in the middle of the day would be when he's sleeping. He usually wakes up about 30 minutes before his 6 p.m. shift. And so he found himself having issues. We discussed how of course, we would have been more proactive, brought this issue up prior to getting this bond violation report so that we could find a schedule that would be more conducive with his work schedule, testing schedule, I meant. That being said, I don't think he's had a single positive test since he's been testing, whether before this, after this, at any point in time. I think he's demonstrated that he takes the court's orders extremely serious, albeit with some hiccups here, but nevertheless stands before you taking accountability for those. And is intent on demonstrating to the court, as he's already done for himself and his family, that he's going to abstain from alcohol.
When I look at this, though, I mean, it's a 3-hour window, and I'm unclear as to why he can't get himself in that window on numerous occasions. I've got 1, 2, 3, 4, 5, 6, 7, 8 missed windows. I mean, in some, he's up to an hour late in terms of testing.
5 in the morning. There's 2 tests. There's 6 to 9 and 12.
Right.
Yeah, so it's 2 months.
Yeah. So, Your Honor, he's working 6 p.m. to 5 in the morning. So basically, he gets home and it's testing windows about an hour later. So he's basically got to fight to stay awake. And then sometimes, again, it's no excuse, but he falls asleep. And so before that 6 a.m. window starts, he gets home at about 5:15, and he's basically got to fight it for 45 minutes to stay awake so that he can submit to it. Sometimes he misses that. And then the 12.
I get that, but there's only one of the tests that's a 6 a.m. test.
And then still
12 to 3 is the next one.
And then the next one's 12 to 3. And then he's saying he sleeps during that, gets up at around 5 p.m., gets ready for work and goes to work.
So I get that. So then why is he missing his 9 p.m. test? Which are 3 of these.
Your Honor, I know of one time I traveled and didn't get there to 12:07. Maybe it's something like a 12:04, 12:07. The other 2, I'm going to honestly say machine. I work, and I usually do that on my break. I'm at work at that during the 9 p.m. to midnight. So I've taken it every time, in my opinion. However, I did notice once or twice that it called for a late register. It said it did not, and I assumed or thought I did. So I do the thing all the time. Like I say, I work, I'm asleep during the 12 p.m. to 3, and I've missed that a few times because I just wake up 15, 20 minutes behind, so forth. But then I'm taking the test, Your Honor. I don't drink.
I mean, I hate to do this, but because if I get, I mean, the cold-hearted reality is that these are really violations of tether. May say there's no distinction between that and drinking, but certainly the court could treat it that way. Is a scram tether going to work better for him? Or the 30 days that he's going to be on something?
What do you want to say?
Your Honor, if I may say, I'm also a coach, so there have been a few times where I was either with the kids or the parents, and I'm always trying to break away, and so I can't do that. So there has been a few times where I'm in the midst of school administrative stuff because I got to blow up between the 12 to 3, and I try to get, and that you can see that they're just a few minutes behind. But I participate as a coach also at Belleville. I'm a coach and for 20 years, and so I am a part active as well as working, and I'm trying to make that time. There are only time.
Well, but you got to make the time.
I have been.
Otherwise, what's going to end up happening is I'm either going to have to incarcerate you, or I'm going to put a scram tether on you, which in dealing with the kids, and I see that it is going to be probably more problematic in terms of what you'd have to explain to them.
Your Honor, when you look at the report, it recommends basically giving him an audition here, 30 days, get it right, or he has no excuse. I think that that's fair and appropriate. I've impressed upon Mr. Sims the importance of showing the court 30 days without a single violation. I think we would respectfully request the court adopt that, give him an opportunity to prove that he's going to be intent on getting it done.
Let me just say, there's a 3-hour window. And you just don't have to wait to the end of that 3 hours. You just have to do it within that 3-hour window. So in that respect, you really shouldn't be missing it. Okay, you just have to find time within that 3 hours to do that. All right, am I understood?
Understand.
Go ahead, Council, as to sentencing.
Well, I just briefly alluded to one of the points was that 30 days on the sober link. I think, again, based on everything we just discussed, I think that's fair and appropriate. We'd ask the court to adopt that. As it relates to the impact panel, we did tender proof of completion to probation, that has been completed as well. I understand that they are recommending the alcohol education program. I think that given what I know about Mr. Sims, that would indicate that he can complete that program and move forward with this. Otherwise, we think that the report and recommendation is fair and appropriate. Ask the court to adopt it.
All right, sir, is there anything you want to say before I impose sentence?
Yes, Your Honor. Once again, I've been a standing citizen. I not only did the court have to give me a penalty or to say I had to do the breathalyzer, I did not drink. I have not drunk since the day of my accident. I'm going to take responsibility of that. Due to leadership, I'm part of I lead kids around and coach and things like that. So I have to make an example for myself as well as others. So yeah, to tether things like that. Yeah, I'm a good citizen. So I don't want to be explaining to these kids, like, the breathing. Like I said, I had to run out and do those things. I couldn't do that openly, but, doing positive things, staying active, and, I just work, stay active with the children and spend time with my grandkids. So I follow your system. I believe I apologize for the times that I was late. However, I believe I was just late, based on activity and or sleep. But I respect the system. I apologize for being here, wasting everyone's time. And I'd like to move forward with you on good behalf.
Who's here with you? Who?
My missus.
Should say that louder.
I didn't.
You like whispered it, like.
Oh no, I didn't think
you didn't want anybody to know. I figured that was.
No.
Buzz.
She's here.
Ma'am, you want him back?
Yes, but I'm tired of fucking reminding.
See, I knew. That's why I wanted to talk to her, because she looked responsible. Like, you're talking about what a good and upstate citizen, and I'm not disputing that, but I think somebody helped you get there.
I sleep during that time period, Your Honor. So
Hold on.
12 to 3.
Hold on. See, why are you talking? She just told me that she's trying to remind you. She's sick and tired of having to remind you.
Understandable.
Right?
Yes.
So, and all that really tells me is that at times, your husband is just not listening. She's trying to get you to do the right thing and follow all along. Am I right, ma'am?
coming for you guys.
Yeah, okay. See, she's still trying to save you. All right. Listen to her.
I do.
She'll make sure that you'll get this done so you don't end up in trouble. You hear me?
Yes, sir.
I guess if she wants you back, I'm not going to stand in the way of that. Court does acknowledge this is not a serious misdemeanor as defined by statute. However, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening assessment identifies the benefit of alcohol. Tell him not to do that. Alcohol highway safety education program and abstinence from all intoxicants for a year. Therefore, the court will follow the recommendation of probation with stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It's therefore the sentence of the court. I'm going to place you on probation for a period of 12 months. In order, $855 fines and cost, $100 prosecution recovery cost, $100 police agency recovery cost, $360 probation oversight fees. When can you pay that?
Within 30 to 45 days, Ron, help with that.
Pardon?
30 to 45 days. Month.
You ask the person in charge when you could pay it? Or are you just making that up?
I just know I'll put
Ma'am,
next
ma'am, ma'am, when can he get this paid? In a month?
the next month's budget.
Well, no, you know what? You just,
The boss has
you
spoken.
need to stop talking. I just went to the brain trust. I got it. She,
Okay.
in a month. So by January 30th?
Yeah.
Thank you, ma'am. I would imagine every time you started thinking on your own. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Alcohol Highway Safety Education Program. You're to provide proof of the victim's impact panel attendance to probation that has been completed. I'm going to continue the sober link for an additional 30 days in lieu of 5 days in jail. Order 93 days in jail suspended. Sir, one thing about me is I've got a very good memory. And your wife told me she's reminding you. So if I have a missed test, late test, anything like that, that means that you're not listening to her. I will use that jail time for that sole purpose.
I would not blame myself for sending you away today for 90 eating, right?
Yes.
Is that one? Defendant charges failure to attend deposit.
5 and number 7 are duplicates. They're the exact same thing, same date and time. But he is pleading guilty to the violations. It's a combination of positives for alcohol and for missed sober tests.
If you plead guilty, so I'll just dismiss count 7. Is that fair?
That's fine.
So he's gonna plead to 1 through 6 and 8 through 12.
Yes.
If you plead guilty here, sir, your probation could be revoked. You could be incarcerated for up to 93 days. Do you understand that? I can't hear you.
So
Did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights. And there will not be a hearing. Do you understand that? I gotta keep your voice up for me, sir. Did you hear what I said?
Yes, sir.
You gotta keep your voice up for me. You understand everything I've said? As to count 1 that you failed. Just give me 1 second. Failed to submit to 7 a.m. PBT on December 12 of 25. How do you plead?
Guilty.
And that's on the sober link, and that was on December 12, right?
Yes, sir.
Did you fail to do that?
Yes, sir.
Count 2 that you submitted a breath test through a sober link on December 13th with positive results. So that would be failing to refrain from consuming alcohol. How do you plead? Did you fail to refrain from consuming alcohol on the 13th? Count 3, that you failed to refrain from consuming alcohol, testing positive again on December 14th. How do you plead? Did you consume alcohol, say again on that date?
It was open 72 hours.
I didn't ask you that. Did you test positive for that and consume alcohol on the 14th?
Positive, yes.
Count 4, to the charge of failed to refrain from consuming alcohol, submitting to a breath test with positive results on December 15th. How do you plead?
Guilty.
Did you test positive that date?
Yes.
Count 5, that you failed to submit to a 7 a.m. PBT on SoberLink on December 18th. How do you plead?
Guilty.
I need Emily in here on this one. Count 6, that you failed to refrain from consuming alcohol, having a positive result on December 16th. How do you plead?
Guilty.
Count 8, that you failed to submit to a PBT on December 18th. How do you plead? Count 9, did you fail to do that? Yes? Count 9, that you failed to submit to a 7 a.m. PBT on December 20. How do you plead?
Guilty.
Fail to do that? Count 10, that you failed to refrain from consuming alcohol, testing positive on December 20. How do you plead? Failed to do that? Count 11, you failed to submit to 7 a.m. PBT on SoberLink on December 21. How do you plead? Failed to do that? Count 12, that you failed to refrain from consuming alcohol, testing positive for alcohol on those dates in times. That date, December 21, at 9:04, 9:18, 9:48, October 18, October 48. I'm sorry, 10:48, 11:31, and then missed on 11:48. How do you plead?
Yes, guilty.
Did you fail to do that?
Yes.
Anybody force you to plead guilty? Please are accepted. The counts 1 through 12, with the exception of 7. Count 7 is dismissed. It's a duplicate. I think I need Ms. DeCino to tell you what's going on in this. Your name?
Alexina,
How disappointing. What would you like to say? I want you to tell Mr. Haynes from the beginning what has happened on this.
so he is scheduled for sentencing on 2 separate show causes on January 14th. There were similar issues, and he was saying that there was something was wrong with the device, so we got him a new device. And they sent his other device out to have it checked if there's anything wrong with it. And then got the new device and we're happy.
So either he should go play the lottery, because I don't remember having somebody have have a malfunctioning device of any kind. Maybe there was. But for someone to have 2, 1 ticket, 150 million. I can't wait to hear, because I am really upset with Mr. Johnson. He gets in sobriety court. We told him it was a marathon. He didn't even get to the end of the sidewalk up here, and he's basically quit. Go ahead. I want to hear.
Yes, Judge, and I don't have the particulars on the hearing that's coming up, but in talking to Mr. Johnson, he's been pretty direct and candid. He's struggling with alcohol.
He lied to me under oath. He lied to me under oath. I want to repeat what I said. He lied to me under oath. I gave him every opportunity to come clean, and you lied to me under oath. You got no business being in sobriety court. We made a massive mistake on this one. What a failure on our part to see through the nonsensical garbage. And I, as the head of this sobriety court, accept full responsibility. You lied to me under oath. You don't lie in a courtroom, son. I don't care what it is. You want to tell me I'm struggling? I'd have been so understanding, it wouldn't have even been funny. You don't lie to the judge, and you don't lie when you're under oath, and you hit both. I feel like terminating him right now. That's how upset I am with him. I really do. I mean, I'm just ready to go give him 93 days and let's move on. I will not tolerate people lying to the courthouse, not me. It's not about me. Not about me. You don't lie to the judicial system under oath. You don't do it. I gave him every opportunity to get off the mat. No. It's a malfunction. It's a malfunction. So I got to have people from house arrest take time from their day to come on. We got to fool around with switching out devices. And then the same thing happens. And I'm telling you, if this was a malfunctioning device, not one, but two, he needs to go buy a lottery ticket. He'll be a billionaire by 6 o'clock or whenever the next drawing is. Unless you think I shouldn't terminate him, I'm doing it right now.
Did he plead guilty?
Yeah, he's pled guilty to all these. And now his lawyer started out, Mr. Haynes, gentleman, he's struggling with alcohol, which is what I knew from the beginning, but he wouldn't tell me that. He wanted to lie to me. He wanted to assure me he didn't. I told him, you're not going to testify falsely under oath. Go ahead.
Judge, you've been around this even a little longer than I have, which is a long time. With this particular problem, you don't know when people are ready. You know when they admit it. You know when they see the light. A lot of times people have lived a long time trying to get away with things, and it becomes a habit. Today, and this is not around for the other part of this. I met Mr. Johnson for the first time today. We talked about it, and pretty quickly we got to the point. He has been involved in counseling with the GARA. I'm hoping the court will order that his counseling is increased, possibly intensive outpatient, because he is struggling with that degree and he needs the help. I don't know exactly what's going on with him in his personal life, but he does have a job. He works at the call center, gets off at midnight. He says he's doing his meetings after that. He's working toward getting a sponsor, but he doesn't have one yet. And maybe getting a sponsor would be the part of this that helps make a difference for him. But if he's made a step today that he's acknowledging this, I hope he gets a chance.
Anything else that you want to say, sir?
No. Give me this option. I won't fail. I don't want to people.
Anything you want to say?
I am with Mr. Hayes in some capacity that I don't think it's uncommon for the early days for people to fight it. I think it is a step in the direction that he was at least honest today. I'm equally as frustrated when I think of the work I put into the other violation. I'm kind of thinking that maybe a scram tether would be appropriate because now we're having an issue that he's missing the 7 and 11 a.m. one. And then I would definitely want to speak to Hagera about getting him into IOP and maybe an MAT consultation. And the ETG did come back and confirm I got it today for the record.
I just don't understand. I just don't understand how when a judge lets you off the mat, and I did let you off the mat. I mean, I told you not to lie to me, and you lied under oath. I get the whole addiction thing. We all get that. Every one of us get that. I don't understand how when I was talking to you and I knew you were lying and you kept assuring me you weren't lying and you testified under oath. I would not blame myself for sending you away today for 93 days. I want to be clear about that. You just got started in this program. And you aren't even giving it a shot. And again, I get the addiction thing. We all understand that people are going to fail. They're going to relapse. I get it. But you went to such great lengths. I'm going to have a hard time forgiving you for that. I mean, you really went to great lengths. But that being said, here's what I'm doing. You're to serve 10 days jail now. I don't care who you're going to be with or not with on Christmas. That's just too bad. That's just too bad. You're going to serve Christmas Day in jail. And for you to make me do that, for me to do that, you really pushed me. You ought to know that. You're to have a MAT consultation. You're to convert to a scram tether first business day following release. So we can even take the sober link that he's on. I don't know where he got it, if he got it from house arrest. Pardon?
He'll have to take it to house, if he doesn't have it with him today, he can bring
Do you
it.
have it?
I would rather him keep it almost, so that when he gets out,
It's going to be,
what if he gets out at 7 PM on a Saturday, you know?
that's fine. I'll let you work on that. You're going to return that. We're going to give you a scram tether, 10 days jail, 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. This is basically, there's no basically about it. This is your last chance. You lie to me again, we're done. Good luck. That's what we'll do. And you can talk to Gary about IOP, intensifying the treatment.
Sentencing for the court.
I do. And we'll see how things go. Thank you very much. People against Bradley Jacob Malat, 25W838481. Your name? Ms. Wilds, your name?
Elizabeth Wilds, probation, Your Honor.
James? All right, I sentenced him June 25th, 12 months probation. Why has he done the positive strategies? And where do we stand with the,
Money's been paid, Judge.
okay,
Ms. Wilds, it's in the system. They said shortly after the violation was filed. Ms. Wilds has indicated the next time is January 22nd for the positive strategy program. We make no excuse for that not being done yet, but he will be able to enroll and do it that day.
what do you think, Ms. Wilds?
Yeah, Your Honor, I kind of agree with what you started off. It's been a minute. I have given Mr. Malat the information a few times in regards to the program. At the last visit I had with him, I told him I couldn't afford to give him any more time to do the program. Mr. Haynes is correct. I did let him know that the next scheduled one through PERS is January 22. I don't think it's without reason to give him a few extra days on the court work program as penalty for kind of dragging his feet, Your Honor.
Yeah, I agree. Anything?
Screw that.
You're gonna pay costs of $100. You are to serve 1 day on court work program and pay $35 for that and pay $35 for that. You gotta be more diligent, young man. Okay?
Absolutely.
So we'll set you up for the day on the court work. I'll send him over there now to set that up with you, Ms. Wilds.
Yes.
And you can pay the $35 now.
Yeah.
All right, make sure you take care of the program. Good luck. Thank you. Stefani, Anthony Stefani. Anthony Joseph Stefani, 25W701244.
With his Anthony Stefani.
All right. Come on up here, Mr. Stefani. I have a probation violation from November 20. He entered a not guilty plea. There's a charge of failure to pay fines and costs and failure to refrain from violating a law, being convicted of public intoxication, offense date November 5, conviction date November 20. Your name, sir?
Anthony Joseph.
How is he going to proceed now?
Pleading guilty to the violence.
All right, can you, Ms. Wiles, I'm gonna need you on this one too. Is that what you want to do, sir?
So,
I'm sorry?
I believe so.
All right, if you plead guilty, I want to make sure that's what you want to do.
So if you want to do, Mr. Stefano?
I really.
Did you not pick up a new case, Mr. Stefano?
Yes, it is.
You pleading guilty?
Sir.
If you plead guilty here, you could get 10 days. Do you understand that?
Understood, sir.
Did you sign the advice of rights and read and understand the rights?
Sir.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right, as to count one that you failed to pay your fines and costs as ordered, how do you plead?
No.
Is the count two that you were convicted of disorderly person, public intox while on probation? How do you plead?
No.
Were you convicted of public intoxication, disorderly person on November 20 of 25, arising out of an incident that occurred on November 5 of 25?
Yeah.
And did you fail to pay your fines and costs?
Yes. Well, no, sir. Yes, sir. I'm late on December.
You didn't pay your fines and costs as ordered though, right?
Correct.
Anybody force you to plead guilty? I'll accept your plea, okay. To both counts. Ms. Wild, your name?
Elizabeth Wiles, probation, Your
What
Honor.
do you want to do here, Mr. Haynes? Can you make any?
Judge, right after that conviction in November, it's in November, actually, before the sentencing, he entered into quality behavioral health. There was an inpatient stay of 30 days there, brought a certificate in, he just got out on December 12th. He set up to pointed that into through October, he had already been on a payment plan. He had been consistent with that payment plan, but he didn't pay the month when he went to the interest program. What we're asking for is for the court to accept that, that he did complete the program and allow him to start up again on his new payment plan with a payment of $100 each month starting February 1st.
Ms. Wilds, can you tell me how much he owes? Do you know? Or have
Yes, Your Honor. He owes on his probation case $1,040, 10.
Still, okay, so he hasn't paid anything. When are you gonna be able to pay that, sir?
Right after the first of the year, sir.
How are you gonna get that money?
Taxes.
Well, you're not gonna file your taxes January 1. You gotta give me a date. What's after the first of the year mean to you?
Back to work. But the gentleman that I've been doing most of my work with, he's off until the first of the year is over.
You were in custody as a result of that conviction, right? When you were convicted of that public intox, how long did you spend in jail? It seems like I had you at the county here a couple months ago, no? Am I?
That was all these I turned myself in. I've been taking care of all my tickets, sir. I've been back and forth, getting all this squared away. We would have been done had this not happened with this public intox. I had paid money. And,
So you didn't really spend any time in jail in November?
yeah, I did the day. I did for this. I had a real bad seizure just a little bit ago, so you have to excuse me.
Take your time. It's okay. I'm just trying to figure out, it seemed like you were in custody in front of me.
Well, yeah, because I zoomed from QBH to show up for court. And he said you wanted to see me in person.
All right. Do you have anything to add, Ms. Wilds?
Your Honor, I think what you're asking, so on that new offense, that one was in front of Judge Hessen. He received 1 day of credit for that offense.
It seems like he was in front of me. I saw him a lot.
We've seen each other a lot this year, sir.
Yeah, he's been on probation since March. He absconded, Your Honor, and then he was in front of you. Got placed, not back on probation, but probation resumed. He was actually supposed to do his education program October 7th. He did provide a medical, so we were going to allow him to do that program in December. But he went out and he picked up this new offense, the disorderly that he's violated for. And right after that, he entered in at QBH.
All right. You said you can pay it right after the first of the year. You really don't mean by January 5th. You mean by when? February 1?
First? Yes, sir. Yes.
Like-
I need the month of February to pay. I need the month of January to get it paid.
You pay this in full by February 1. Judge Hessen presumably took care of whatever punishment was deserved on the other. I'm gonna go ahead and let it go with that. Let's get your life back in order though, Mr. Stefani, okay, please? All right? And now, if you need more time, if you don't have the money, it's not a problem. Just call the court. We'll go on Zoom or walk in here on before the due date. I'll give you an extension.
Judge, I wasn't aware that he was waiting on a tax refund to take care of this. We have March 1st instead of February 1st.
Well, he's got probation coming up when it's. Is that what you're gonna do is with your tax returns?
Well, that's what I was planning on.
All right, we'll do it March 1. You just gotta diary that up, Ms. Wilds, because probation ends March 18th. So if we don't have it March 1, we're gonna have to show cause them, okay? If you need more time, you call the court, we'll go on Zoom. All right? Or you can come in here on it before that due date and I'll give you an extension. Good luck. Merry Christmas to you. Thank you. Stay out of trouble now, please.
That's it.
Thank you.
Thank you, Judge.
Thanks, Ms. Wilds. I think that's it for you, or you got another one?
Dylan Hall.
Dylan Hall, Dylan James Hall. 25B148-235 A and B.
Who would take Dylan Hall?
Sir, your name?
Dylan James Hall.
So he had a case taken under 7411 and HIDA, right? What did we do here? Let me see. You got a drug charge that was taken under 7411. You got a CCW charge taken under HIDA. And he was ordered to attend and complete the substances of abuse program. And they think he didn't complete it. How's he going to proceed on this?
Guilty.
Is that what you want to do, sir?
Yes, sir.
I'm gonna need Jessica on this. If you plead guilty, this would be your second violation. And you could get 10 days in jail. Do you understand that?
Yes, sir.
All right. Did you sign an advice of rights and read and understand the rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
Yes, sir.
To the charge you failed to attend and complete the substances of abuse program, how do you plead?
Yes.
Did you fail to attend and complete that?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
Just give me 1 second. You did not attend, correct?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
Why didn't you attend the program, sir? Can you tell me?
I did accidentally yesterday.
Accidentally missed it. Your name?
What's going on?
What do you want to tell me, Mr. Haynes?
That he needs to get the program done. I think it's an 8-week program. I don't know how much longer he's got on probation, but if he is going to need an extension, we'd ask the court to extend his probation on the.
July 30, you were ordered to do this. Why you been fooling around like this?
Got to get it done. I did.
Forgot to get it done.
He started the program at one point, then he missed the day, so.
Yeah.
What do you want to say?
Intake back in November 3rd, and then the next class didn't start until the following month, and that was when he then missed the follow-up. So he missed a follow-up for the weekly sessions on December 7th and then December 14th.
And how long is the program again?
The program's it's 8 total sessions that he has to complete. So well, technically it's 9 altogether. It's an intake and then the 8 sessions. So he's completed 1 out of 9. And I don't know when their next session starts because right now they're in one and they're not gonna let him join in now halfway through.
Probation, he's supposed to be here
Yeah.
for a review hearing January 14th. So I made a mistake on this one. Give me 1 second. Okay, he was placed on probation July 30, so he's scheduled to come off January 30. I'm gonna have to extend your probation for 3 months until April the 30 of 26, pay additional costs of 75, additional probation fees of 60, serve 1 day on the court work program and pay $35 for that. So you owe $170. We're gonna have to remove the review hearing date, Heather, so we're gonna have to make it closer to the latter part of April.
Okay, Judge, we have Brownstown, April 22nd.
That would be good. So the new review hearing date will be April 22nd at 9 o'clock, sir. April 22nd at 9 a.m. New review hearing date. So we're going to give you that. And you're going to go down the hall, pay your 175. Do you have that? Yeah. Pay that and then go back and talk to Ms. O'Donnell about setting up your court work program day. You gotta stay on this. Good luck. Merry Christmas. Thank you. Thanks, Mr. Haynes. Thanks a lot. Take care. I think so. Man, what do you have here? What do you hear on?
She's it's 10:37.
Oh, are they here? You're all set, I think, Mr. Haynes. Is Mr. Haynes all set to go? Heather, do you know if we got all these done? I think.
I do not have anybody on Zoom, so as long as everybody in person is done.
Still looks like there are gonna be no shows, Church and Davis.
What time were they scheduled? We'll put them on for warrants and yeah, you can go.
Yeah, 9:15.
Yeah, we'll just issue warrants.
Yeah, I'll do them later.
You're all set. Merry Christmas to you, Mr. Haynes. Thank you as always for your help. Are you on that Spice? Are you Spicer?
Yeah. I have Mr. Lochner in Zoom, Judge. I can let him in. I
Yeah,
wasn't
please.
aware who was in there, sorry.
John. You might need mine. With the motion on this. The trying briefing. Mr. Stevens is.
Oh, yeah, you didn't check. I didn't know who that
St.
was.
Louis, they're up at 10:30, so I need the motion on Spicer, which is on my desk. Trial brief on that one.
Is that on your desk too?
St. Louis, yeah. Do I have Capital One versus Emily Burke?
I have plaintiff here. I don't have defendant yet.
Jeez. I don't even know what this is up for. Owners Management versus Justice Spicer, 2502423. Come on up here, man. Mr. Lechner, your appearance?
Good morning, Your Honor. Attorney David Lechner, P number 67994 on behalf of Owners Management.
Hi.
Your name, ma'am?
Justice.
All right. No, not yet, Miss, let me, did you read her motion, Ms. Spicer's motion?
I read it, Your Honor, and before we get into it, I spoke with my clients. We're willing to withdraw our petition to reopen the case at this time and let Ms. Spicer finish out her probation. I do want to say that, just for the record, that she agreed to this probation and the probation said no violations of the lease. The lease doesn't allow for pets, whether it's her pet or I know her contention is that it was a visiting pet or she had a visitor who brought a dog over. That's still a violation of the lease. And a noise complaint, whether it's on Halloween or any other day, is still a noise complaint. So going forward, I want Ms. Spicer to be aware that although we're withdrawing it at this time, while she's on probation, any violation means any violation. But at this time, we'll withdraw our petition to reopen the case.
What was the basis by which you had indicated that she did not comply with the judgment?
There was a violation for an unauthorized pet, and there was a violation for a noise complaint, a noise violation late at night.
I know. Did you set those for hearing, or did you just file an affidavit of non-compliance?
I just filed an affidavit of non-compliance to reopen the case and waited for Ms. Spicer to file objections, which she did.
All right, so we're back to square one. You're withdrawing your petition to refile, reopen the case. Your client has apparently accepted rent for December, right?
I don't know. I don't know that because we filed this back in November, so they might have put a hold on Ms. Spicer's ability to pay rent. Usually that's their standard operating procedure when there's a an action for eviction, they stop accepting rent. So I would defer to Ms. Spicer. My client's not here right now. I would ask Ms. Spicer if she was able to pay rent or not. If she wasn't, I will reach out to my client so that they open up the portal so that she can pay her December rent. We would not at this time be aggressing against her for failure to pay rent, because if she didn't pay it, it was because she wasn't allowed to.
Right. She said in her response she already paid for December. So are
Okay,
you
then-
satisfied? They're gonna withdraw their petition to reopen the case. Okay. So you are all set. Merry Christmas to you, ma'am.
Thank you, Your Honor.
Capital One versus Burke. 2502019. Mr. Saloom, your appearance.
Good morning, Your Honor. For the record, William Saloom, P41487, appearing on behalf of plaintiff.
Where is Ms. Umi? I saw her out there.
Yeah, I
moments
just spoke to her in the breakout room. Hopefully she's getting ready to
She should be
join.
coming back in. I just requested her to rejoin.
Okay.
Okay.
And we haven't been able to come to an agreement, Your Honor, so I guess we will need the court to make a determination.
I'm not even sure what you're here for.
That's a good point, because technically, I guess we're here on her motion for a stay. If she wants-
Judge, excuse me, counsel, if I may.
Yeah,
This was
go
the
for it.
one that we had received a motion from Ms. Verk requesting the court date moved up on her objection. The garnishment hearing, I believe it was. And
Yeah,
then
I
you had
think
asked
she-
that I move the date up.
Right.
Ma'am, your name, ma'am.
Ume UMMIVIRK, Ume Verk.
Your Honor, I think what happened is she filed a motion for installment payment scheduled for January 13th of 2026. We have no objection to that being heard today. I guess if we hear it today, then her motion for stay becomes a moot point. It's up to the court how the court wants to deal with the motion.
All right. So I'll just go ahead and hear your motion for installment payments now, ma'am, okay?
Yes.
Tell me why you can't afford this. I'm vaguely remembering what you're talking about, Jennifer, but not really. I remember you talking to me about how I wanted to proceed on this with regard to moving the date up. I vaguely remember that. What are you asking to be able to pay, ma'am?
My mom is not able to speak English well, so can I speak on her behalf?
Yeah, well, what is your name?
Marine Verk.
All right, so I got to be a little careful here now. I didn't know that, or we would have gotten an interpreter. I can't really let you, can you translate for me? I can do that so I can expedite the hearing. Can you speak to her and translate? I can't let you represent her.
Yeah,
All right, so your name is Marie Verk.
Marine Verk.
How do you spell your first name?
MEHREEN.
All right. And what language do you speak? You speak English, obviously. What does your mother speak?
Urdu.
And you also, are you fluent in Urdu?
Yeah.
Any objection to me doing it this way, Mr. Sloom?
No
I mean, I
objection,
can't get
Your
an
Honor.
interpreter here this second.
No objection, Your Honor. I don't think it's a real complicated matter.
Right.
I'll let, yeah, no objection.
Ms. Burke, young lady, raise your right hand. You solemnly swear or affirm that you will make a true and accurate translation between the court and the parties here. In other words, you're going to translate to your mother, you're going to translate to me and the lawyer what your mother's saying. You promise to tell the truth and do that and make a proper translation under oath?
I do.
Okay. Now, all right, put your hand down. Now you're going to ask your mother, you're going to repeat exactly what I say to her, and you're going to repeat exactly what she says to me. You can't engage in a side conversation with her, okay? Fair enough?
Okay.
All right, ma'am, tell me
Yes,
how
sir.
much you think you can afford to pay. You're going to tell her that.
Okay.
I can,
पुस्तक है अभी तू किन्ने देने ने
I can afford at the most $20 a month.
How much?
$20 a month.
Do you
$20.
work? Wait a
Yeah.
minute, this isn't working. I thought you said she can't understand English and she's talking to me.
She can understand it, but not really well.
Well, I need you to translate for me, okay?
Okay.
Tell me why you can only afford, and you tell her this, tell me why you can only afford $20 per month.
क्योंकि मेरी minimum
तू मेनू गल क्यों नहीं करन देंदी तू ओनू 10 भी तू ओनू $20 per month क्यों सिर्फ दे सकनी है
क्योंकि मैं मिनिमम वेजेस ਤੇ ਕੰਮ ਕਰਨੀ ਹੈ ਤੇ ਮੇਰੇ ਐਕਸਪੈਂਸਸ ਬੜੇ ਜ਼ਿਆਦਾ ਨੇ ਤੇ ਮੈਂ ਸਿੱਖਾਂ ਮੇਰੇ lot of bills ਨੇ ਮੈਡੀਕਲ ਬਿੱਲ ਥੈਰੇਪੀ ਦੇ ਹੈਨਰੀ ਫੋਰਡ ਹਸਪੀਟਲ ਦੇ ਵੇਨ ਮੈਟਰੋ ਹੈਲਥ ਦੇ ਤੇ ਇਸ ਵਜ੍ਹਾ ਤੋਂ ਤੇ ਮੇਰਾ ਰੈਂਟ ਵੀ ਹੈ
Come on, you got to tell me now, please. Tell me.
She said that she can't afford it because she is working on minimum wage and because she has a lot of medical expenses and therapy expenses
ਇਸ ਵਜ੍ਹਾ ਤੋਂ
because of her shoulder rotated cuff is broken and she needs surgery for that. So she's been going to therapy and to the hospitals and appointments, and she has a lot of medical expenses.
Mr. Saloom, tell me what you're asking for. And I want you to go slow so this young lady can interpret.
Yes, Your Honor. So pursuant to the garnishments, we were receiving, I think, approximately $630 a month. But we would agree to accept $300 a month. We've tried to work out a payment plan with her, but haven't been able to do that.
She's only making $2,400 a month. She's got a motion here that says she pays $1,800 in rent and $600 in utilities.
I see. Your Honor, I guess a more reasonable request would be $150 a month.
Well, I'm going to make it $40 a month. Sorry. I'm going to ask you to tell your mother, ma'am, tell her, I'm going to order that you pay $40 per month.
And $40 per month.
And I'm going to ask you to prepare an order to that effect, Mr. If you would, please.
Yeah, we will. There may be one in the file. I don't know. Well, maybe not. But in any case,
$40 per month beginning January 10th and the 10th of every month thereafter until paid in full.
There's something my mom wants to tell, and it's that she recently filed for a medical leave at her work where it wasn't covered, and she works part-time now, and it's hard for her to manage the expenses, so she wants to know if you can please go down. And she barely goes like 2 days a week now.
Jeez, I can't do much better. I'll make it $25 per month, and I'll start it beginning February the 10th. And the 10th
Your
of
Honor,
every month.
if I may, this is approximately a $10,000 judgment.
I know.
And I appreciate her predicament, but whether it's 25 or 40, that's just, that's something people kind of work with, whether they're up or down as far as meeting their obligations. And, I think the court knows my position. Yeah.
I get it, but that's my order. $25 a month starting February 10th. $25 a month starting February 10th. Now tell your mother, they still can garnish. They still can garnish. Listen. they can still garnish they can't garnish wages, but they can garnish tax returns, bank accounts, and the like. So she needs to understand that. They still could garnish her tax returns. That's the best I can do. Tell her, would you please tell her everything I'm saying?
ਉਹਦੇ ਬੈਂਕ ਅਕਾਊਂਟ ਦੇ ਵਿੱਚੋਂ ਤੇ ਟੈਕਸਸ ਲੈ ਸਕਦੇ ਨੇ ਤੇ ਇਹ ਸਭ ਤੋਂ ਬੈਸਟ ਉਹ ਕਰ ਸਕਦਾ ਹੈ।
Can't do better than that. I'm sorry.
She wants to know if she can send the installments on her own.
Yeah, tell her where to send them, Mr. Saloon.
Yes, that's fine. We're going to send an order to the court for installment payments of $25 a month beginning February 10th, 2025.
ਉਹ ਵਿੱਚੋਂ ਆਪ ਪੂਰਾ ਕੱਢ ਸਕਦੇ
And, we'll have a P.O. box and an address where she can mail the payments to us.
Tell her that. Tell her that.
ਉਹ ਆਂਦਾ ਬਈ ਉਹਦੇ ਨੂੰ ਐਡਰੈਸ ਸੈਂਡ ਕਰੇਗਾ ਜਿੱਥੇ ਤੂੰ ਉਹਨਾਂ ਨੂੰ ਸੈਂਡ ਕਰ ਸਕਦੀ ਹੈ।
That's it. Thank you both. Have a good
Yeah.
day.
Thank you, Your Honor. Have a good day.
Thank you. Happy holidays, Mr.
Oh, Your Honor, one last thing.
ਪਿਛਲੇ ਦਿੱਤੇ
Is there, I don't know if there's a pending garnishment, or I know it was filed in October. It's some.
Is there a garnishment already filed in this?
Judge, I'm pulling up the garnishments right now.
If there is, I would just ask that anything being withheld be released to plaintiff's counsel.
Yes,
Yeah,
there was one issued in September.
If anything's been withheld, tell her that on the garnishment, it's going to be sent to the plaintiff lawyer. On the garnishment.
ਜੇ garnishment ਦੇ ਵਿੱਚੋਂ ਕੁਝ withheld ਹੋਇਆ ਵੇ ਤੇ ਉਹ plaintiff lawyer ਨੂੰ ਮਿਲਣਾ ਵੇ। What does
Okay.
that mean?
It means if her wages have been garnished, then her employer's been keeping the money and they are going to send that to Mr. Saloom and the plaintiff's lawyer. Okay?
So she's not gonna get them?
No. No.
Okay.
Okay?
Your Honor, do you need us to do a order on the?
All of that. All of that. The sooner
Okay,
the
we
better,
will.
okay?
We'll
Thank you.
submit both. Thank
Thank
you.
you.
Have a good day.
She
You
wants
too.
to know if she can get the garnishments back.
No. No. Okay, I've been too fair. I haven't been fair with them, if anything. Have a good holiday, everybody. What's your name?
You as well, Judge. Thank you. Everyone have a good
What's
day.
that?
Davis.
Is that up for today?
11 o'clock.
You guys get, how much is this case worth, Mr. Scanlon?
Oh, no change.
$1,000, Your Honor.
You guys can't resolve this?
Get the trial brief. Mr. Lewis doesn't have.
Mr. Lewis doesn't what?
Doesn't have a cause of action, Your Honor. Based part of the fact that my client has spent over $2,000 in material.
Come on up here, guys. Give me the file. I need the file. John, why don't you move all those? We're gonna have to have them sit there. Huh?
You should have that one.
I got this.
Should have, I put it up.
Mount St. Louis versus Brian Marshall, 2502190R. Everybody, state their name.
Please stop before Gerard Scanlon, P number 74992, hearing on behalf of the witness Brian Marshall, the president to my right.
Your name, sir?
Morning, Your Honor, Brian Marshall.
Mr. St. Louis, your name?
Donald Taylor.
All right, let me just look back and file momentarily here. All right. All right. You know what? I hate this M filing. I just don't get it. I'm all for change if it makes it better, but it hasn't made it better. It's made it 4 times more complicated. So I don't have a small claims. This was initially filed in small claims, right?
That's correct, Your Honor.
Jennifer, have somebody bring me down the small claims affidavit. Before
pulling it
then,
up
I
right
had,
now.
before then I had files. It was a lot easier, but
Your Honor, if I may.
yeah, you can handle that. Thank you. All right, so I've got Mr. St. Louis claiming for labor performed. You're claiming 2789, right? Mr. St. Louis?
He returned my tools after.
How much are you claiming?
Just the 2,000 plus the court fine.
$2,000. What's the $2,000 for?
Wages for all the work performed.
Okay.
Up to the point of where we had to move to another job because 2 weeks turned into 4 weeks and it wasn't going anywhere because he wasn't.
All right, okay. Sit down, everybody. Give me your opening statement, Mr. St. Louis. You can tell me what your theory of the case is.
We were working on a job on Philly and Allen Park. Carlos, my partner, and myself. For him. He wrote it up and doing the job. He approached us about his girlfriend, homeowner / Lauren. Wanted to have a bathroom redone. So, for the record, he's my stepson, you know. So I went one night, met him at Lauren's house. And she went through the whole procedure of what she wants to do. Can she do this? How she'd like to have it done. And I'm like, okay, so when it was all said and done, she went around in another part of her home to water plants. And he said, well, how much are you guys going to charge? I said to do all that work, except he was going to do all the tile work in the bathroom. She's fine. I said 4,800. We had a week to go still, and then when she went on vacation, because it was a 2-week vacation she was taking, I started. The first night, the first time in there, he was in there and started helping, and I asked him, I says, what are you doing? Are you taking away work from Carlos and I that you wanted us to do? And he goes, well, I'm just helping you get going. Don't worry, you're gonna get all the money. So I continued to go. Carlos would come when he was doing the skin work, the finished muddy over on another job. So he'd go there for a couple hours, then come over and put it together. We completed demo of ripping out all the walls and everything.
All right, I just want to hear what your theory of the case is. He owes you money.
Right.
He owes you $2,000.
I'm being generous on that, Your Honor, because I'm going to go on. Just being fair about it. For the amount of time and work I had to put in with him, including using my truck 2 times to go to Home Depot, meet him, load it up with cement, go back to her place, mix it, and all that. He just, for some reason, couldn't stay out of getting it so involved in this, and there was the problem. He was supposed to supply all the materials, we could have been in and out. But it didn't happen. So we put up with it to the point where the other job, Mr. Phillips in Dearborn Heights, had already, we backed him up 1 week, going into totally doing his whole remodeling on kitchen and everything. And finally we had to go 4 weeks. He wanted 2, so we got it done in 2. I said, yes. But at no point were we supposed to deal with him being involved with, he works for major contractor. He ain't even around during the day. And then twice on weekends, he was gone. Once he took his daughter up north to visit the grandpa. Okay, that's fine. But we could not get the material to complete this job. So I figured.
It's your paperwork. It's wise to be.
Good. I figured we normally figure out jobs out at $30 an hour labor. I got at least 80 hours, actually probably more, but I settled for 80. Carlos got 12 coming there. And that there would have been 24 on me and another 340 on him, something like that. So I just went down to 2. That was it.
All right, okay.
The only thing, but we don't track hours. We bid a job according to what the job is worth on the market. So that's why I said 4,800, but if I had to be reasonable, because they brought it up, wanting to know how many hours. Well, we don't track hours, but if I had to give a rough guess, that's where I would put it. To, you know, about 20 some, just over 20 or pardon me, we are 80, about closer to 90 hours 90. But I'll settle it, I mean, simple math.
So you're charging $100 an hour, basically?
No, $30 an hour times 80 hours. That's 2,400.
Okay.
And 12 hours for Carlos when he was there helping me with all, as I submitted into your file, as you instructed to make sure I complete the thing for the court. There's pictures there, but that's not pictures of all the work that was done. I took pictures of a
All
lot.
right, okay, let me hear from you.
Main premise of this cause of action, Your Honor, is that my client didn't supply the materials from the job.
Did.
Didn't. That's the main premise. Didn't supply the materials. That's what he said. When asked in an interrogatory to describe how the breach occurred, his answer was Brian failed to supply the materials for the job. And I've got receipts that show clearly that my client has spent over $2,000 in materials and he's prepared to testify with it. Further, I've also cited a case in my trial brief. This is the Van Dyke's case that indicates that when a job is done for a family member, which Mr. St. Louis has already testified that my client is the stepson, it's done for and gratuitously done and or furnished. In that there's a presumption that arises that Mr. St. Louis is going to have to overcome according to the case law. He has no cause of action, he has no damages, my client supplied the materials, and thus we're asking that the case be dismissed and costs and attorney fees be awarded.
We did some work, though. Nobody's disputing he did work, are they?
That's not the nature of the breach. The nature of the breach is, according to him, in his own words, in the interrogatories that I'm going to introduce as evidence, the nature of the breach is that he failed to supply the materials. My client has received from Home Depot indicating that the materials were purchased and he's prepared to testify that he did purchase them.
All right.
Therefore, he has no cause of action.
Call your first witness. Call your first witness. If you want to testify, you can come up here. If you don't, you can call your friend here, or you can call the defendant here, or call whoever you want. But you got to come up and I'm going to swear you to an oath. That was just an opening statement before. Yep. Raise your right hand. You solemnly swear to affirm the penalties of perjury. With the testimony you'll give in these proceedings will be the whole truth self you got. Have a seat. All right, go ahead and tell me. Now you can be detailed. Go ahead, tell me everything you want to tell me.
When I went in there, they had already been doing shopping. A toilet somewhere, it was worth
Are you charging for the labor or for the materials?
just the labor. The agreement was he's gonna supply the material when I needed it, not purchasing a cabinet here, a toilet that was all done before we even started. I mean, going in, they had stuff stockpiling, so if this material for receipts is where he's going, the only materials he bought while I was there working was copper, piping, fittings, shut-offs, the PVC 3-inch, 2-inch, and 1.5 inch for the drain systems. There was some lumber.
Sir, I'm asking you, are you suing for labor or materials or a combination thereof?
Just labor, sir, Your Honor.
Just labor.
Here, that's all, Your Honor.
All right, and how many hours labor did you have?
I'm saying, I can safely say I put it at minimum 20 hours labor. We charge $30 an hour labor. That's a very good rate in this kind of.
Okay, that's $600. How are you coming up with 2,000?
80 hours.
You said 20 hours.
Oh, I'm sorry. I'm wrong. 80 hours, 2 weeks. I was there for over a 4-week stretch, in the evening and on weekends.
And what did you do in that 80 hours? I'm sorry?
Finished demoing all the old walls and everything. Then I had to remove piping. And
If you've made a decision or if you know what you're doing yet.
Yes, Your Honor, I do agree January 5th would be the deadline for filing that motion. And we are intending to file that motion and working on it right now.
Okay. So with that then, Ms. Olson, when we received that motion, I guess I'll hear input from you on what you envision for a timeline. When that motion is filed, then we'll have to conduct the full Miller hearing. So when the motion is filed, should we schedule it for should I set this for a status conference in February or something, or what do you think is our best next step?
Yeah, yes, Your Honor. I would say, knowing that they will be filing a motion, perhaps even setting a scheduling conference for March would be a time when we might be able to record a good idea of how long the investigation is going to take. We were just fairly recently appointed. We don't appear to have complete MDOC records. I note that Mr. Carlson came here from out of state. So I think a scheduling or status in March, we'd have a much better idea of what we're looking at in terms of time frame for investigation and mitigation.
Okay. Mr. Clennon, any objection to that?
No objection, Your Honor.
Right, so what we'll do then is we'll await the prosecutor's filing of that motion by the January 5th deadline. We'll set this for a continued status conference on Monday, March 2nd at 9 a.m. And I will allow appearances by Zoom. And Ms. Olson, just let us know at any point if you want Mr. Carlson to appear by Zoom. You can just let the prosecutor's office know, and they can prepare a video writ so that we have DOC Zoom him in. And then at that point, we can see how much time you need to complete your investigative work and how many days we need to schedule for a hearing. I imagine it would probably be a couple days at least.
Yes, Your Honor. Generally, the hearings do take 2 to 5 days, honestly, but we'll have a much better idea in the future. So I appreciate that.
Okay. All right. Anything else that we need to accomplish today from the people's perspective, Mr. McLennan?
Nothing I can think of, Your Honor.
Ms. Olson, anything from the defense?
No, Your Honor. Thank you.
Okay, thank you. We'll next call the case. As I said, March 2nd, 9 a.m. and Zoom appearances are fine. All right. Have a good day.
Thank you.
threats or any promises outside the terms of the plea agreement. Do you understand that?
I do.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal, you'd have to seek permission. You would do that by filing an application, but the types of issues that you could raise on an appeal after pleading guilty are very limited. Do you understand that?
I do.
All right, the plea agreement provides an exchange for your plea to the charges I outlined for you. The other charges will be dismissed, and there is a sentence probation, and if you violate probation, you could get jail. But at understand that?
Yes.
All right, now that sentence agreement is not binding on me, meaning I don't have to follow it. But if I didn't want to follow it, you'd be allowed to withdraw your plea, not having received what you bargained for. Do you understand that?
Yes.
There's a very important exception to that rule. Here's what it is. If you engage in any misconduct between now and the time of the sentencing, by either not showing up for court, absconding on your bond, violating your bond, or committing new crimes, that type of misconduct would cause you to lose your right to withdraw the plea, even if I did not follow the sentence agreement. Do you understand that?
Yes.
Has anybody promised you anything other than the terms of the plea agreement?
No.
Has anybody threatened you to make you plead guilty?
No.
Is it your own free choice to do so?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge in count 5 of possession of methamphetamine?
Guilty.
How do you wish to plead to the charge in count 6 of use of fentanyl?
Guilty.
So back on March, in early and mid-March of 2024, were you in Sheboygan County?
Yes.
Were you, while you were in Sheboygan County, in possession of the controlled substance methamphetamine?
Yes.
Did you know that you were in possession of that substance?
Yes.
And did you have any lawful authority in the state of Michigan to possess that substance?
I did not.
Mr. Gilbert, is the use going to be a use or a possession for the factual basis?
It's probably going to be a possession.
Okay. And so, Ms. Johnson, back in that same time frame while you were in Sheboygan, were you in possession of the controlled substance fentanyl?
Yes.
And did you know that you were in possession of that substance?
Yes.
Do you have any lawful authority in the state of Michigan to possess that substance?
No.
And based upon that, I would find a factual basis for the lesser charge of a use. Mr. Gilbert, are you satisfied with the factual basis?
I am, thank you.
Ms. Goodrich?
Yes.
Mr. Gilbert, are you aware of any?
That I can go, I've been years before without drinking. I just drink and then just stop.
Well, at a 0.20 and above, most counselors and scientists that I've talked to, and I've gone to lots of educational programs on this over the years, they tell me that that's somebody with a pretty advanced level of the body accepting alcohol and having a higher tolerance level. So it's not just something that everybody can get to. If you're a infrequent user of alcohol, you would pass out before you can get to a 0.20. So what that tells me is that you are a heavy drinker when you drink. I believe you when you tell me that you don't drink often and have gone long periods of time without drinking. But it tells me that you really hammer it. You drink to the point of oblivion, or drink yourself right into a coma almost sometimes, in order to be able to handle that. And that tells me that you do it often enough that your body can tolerate that high level of drinking. And that's a scary proposition, because while you can handle not drinking for long periods of time, once you start, you can't stop. That's generally what the people tell me about people that have a 0.20 or greater. Am I describing you accurately?
Oh, yeah, it sounds kind of close. Pretty close, Your Honor. I can go long
So-
periods of time without it, but yeah, when I do,
Yep.
it's like, hey, have a
All
lot.
right. So what that tells me is you've got some ability still to control it, but once you start, it gets out of control pretty quickly. And that's hard for that kind of a person to make the commitment to not use alcohol, period. Because they say to themselves, well, I can control it for long periods of time, so I don't need to worry about it. I'll just keep controlling it. And they don't put the work into what is needed to be able to control it once they get started. You see what I'm saying?
Yes, Your Honor. Can I also add that prior to this, I quit for almost a whole year just because for the fact of my children, they've seen me drink before and they wanted me to stop, so I just woke up and stopped. But then, like my attorney has previously said, I was out on an injury at work and just getting stressed and just kind of like you said, just kind of hammered it, I guess, and shouldn't have done that.
Yeah, and I see that a lot. And I'm not saying that you're a bad person because of it. I'm simply saying that it's going to be more difficult for you in the long run because you are able to control the urges for long periods of time. So we get complacent. People like that say, well, I can do it for 6 months or a year. I'll just keep doing it that way. And I'll just rely on my own willpower to do it so that they don't put the effort into AA. They don't put the effort into their substance abuse classes. They don't put the effort into counseling. They don't deal with anything other than their own willpower to not do it. And eventually, all of us have issues with our willpower. We get tired, we get angry, we get whatever, stressed at work. And something like that overcomes our willpower. And then we do what you did in this case. We get out of sorts and we do something that we normally wouldn't do. And in your case, that means pounding alcohol to the point where you're greater than a 0.20, and then you really are out of control because your mind isn't controlling what your body is doing at that point in time. And that's where I've got a problem. I got to figure out a way to get you to understand that this is a disease that you can't necessarily control just with your own willpower. You've got to have some training. You got to have some backup. You've got to have people surrounding you that help you when you get to those I'm stressed out days. You got to have a plan in place. All of those things that you learn through substance abuse treatment. So I said all that to say this. You've got a problem. And it's not going to go away by just you having an iron will that says, I'm not going to drink anymore. That's good, and it will help you a lot, but it's not the only thing that you can have in your toolbox. Have I made myself clear?
Yes, Your Honor.
All right. I'm looking at your criminal history, and you don't have a huge one, but you do have some. So I'm gonna put it this way. I'm not gonna put you in jail today, but you are gonna do some community service work through the work camp in order to remind yourself that if you get yourself into any more trouble, you are gonna go to jail. You understand that?
Yes, sir.
All right. So you've had enough wake-up calls in the past for me to say, I'm at least thinking about what to do with you in jail. Because this is your first drinking and driving related, I'm not going to put you in jail this time. But if there's any probation violations, or if you come before me again on something similar, or quite frankly, anything else, you've earned at that point some jail time. You got out-of-state criminal history and you got in-state criminal history. Nothing major, but enough to say, cut it out. Time to
Yes,
grow
sir.
up. All right, enough said. So here's what we're doing on our sentence. You're gonna be on probation for 6 months. There's $180 in oversight fees for that. There's a mandatory crime victim fee of $75, a justice assessment of $50. Court costs in the amount of $400, fines in the amount of $200, and a local charge of $15. Let me add that up for you. It's a total of $920. You can pay that over probation. If you want some assistance, you may also perform community service work in lieu of some of those fines and costs at the discretion of the probation office. You must enroll in and successfully complete a treatment and educational program that was recommended by Catholic Human Services. That includes outpatient substance abuse. And follow all the recommendations. I don't often do this, but I am going to require you to go to self-help meetings. That means AA or NA or similar, 1 time a week for 3 months. And the reason that I'm doing that, you can certainly go more than that if you wish, but I want you to have access to people in the substance abuse community that can assist you once you're off of probation. I want you to know where they are, know where the meetings are, so that in the future, if you get to a point where you say, my will isn't enough, I'm having those triggers or those cravings, or something's happening where I think I need to drink, now you know who you can call and who you can talk to and where you can go that can help you with those situations. While you're on probation, there's no consumption or possession of alcohol or drugs. There's no entrance into a business where alcohol is served by the glass. That means no bars, even if they happen to serve food. You can go into a restaurant that happens to serve alcohol, but you can't go into the bar portion, and obviously you can't order alcohol. There'll be drug and alcohol testing at the discretion of probation. Not going to put you in jail. I am going to require you to do 3 days of work camp within 30 days. So you can schedule that through your probation officer. All right, Mr. Fortier, is there anything else that you would ask of the court?
Because I didn't hear the 170.99 to give
All right.
his partner.
Yep, thank you very much for reminding me of that. I will add $170.99 in restitution to Gaylord City Police Department, and that adds $170.99 to your 920, which means your total is $1,090.99. And again, that can be paid over the course of probation. Mr. Brown, anything else?
No, Your Honor, thank you.
That'll be the order of the court. Mr. Krieger.
I'm sorry.
Let me give you the number. That's all right. I said, Mr. Krieger, let me give you the number to the court's probation department. You can call them tomorrow. 731-0215. You have any additional questions, Mr. Krieger?
No, sir. I think that's it.
All right. Good luck to you. Merry Christmas. Hope
Thank you.
things go
Merry
well.
Christmas, Your Honor.
State of Michigan versus Jesse Allen, file 25-44146-SD. We have Mr. Allen with us.
Ask him to unmute and start his video.
I'm here, Your Honor.
If you could start your video, please, sir. All right, I do see Mr. Allen is with us. Mr. Brown, do we have a resolution of this matter?
We do not at this time, Your Honor. I did speak with Mr. Allen. I am going to request a brief adjournment in the matter. There are some other issues that I want to go over with him, as well as speak with Mr. Fortier about.
All right, we can certainly do that. How long do you need to accomplish all that?
Your Honor, I think a couple of, well, probably the first date after the holidays would be fine, whenever the court's available.
Any more time in a second?
Yep, we got room in a second.
Afternoon or morning?
It'll be the morning.
All right. January 2nd at 9 a.m.
That's fine, Your Honor.
All right, Mr. Allen, we'll do this Zoom meeting just like we did today. We'll do that on January the 2nd at 9 a.m. In between now and then, you need to speak with your attorney to make sure that you understand everything that he's got going on, and he'll talk with the prosecutor and discuss matters with you related to resolving the case. And we're going to try to do that on January the 2nd if we possibly can. Do you have any questions for me today, Mr. Allen?
No, Your Honor.
All right. I'll talk to you on the 2nd then. Merry Christmas.
Thank you. Merry Christmas.
Next matter is the State of Michigan versus Shelley Strauss, file 19-37055-SM, set for a bench warrant arraignment. We have Ms. Strauss with us.
I do not see that name.
All right. Looks like Ms. Strauss is here or is supposed to be here for a bench warrant arraignment, but has failed to appear. This is an old case. And looks like she has a number of failures to appear back in the case file as well. And looks like she pled on June 6th of 2019, failed to appear for sentencing on 6/27 of 19. And then there was a bench warrant issued on July the 11th of 2019. And that is, she was recently picked up on that and has now failed to appear again. So we're going to do another bench warrant. Bond in the previous one will be canceled, and a new bond will be set, this time of $1,000. Next matter is State of Michigan versus Amanda Woyrol, Woirol, file 25-44038-ST, set for a status conference. I see Amanda is with us. Ma'am, could you pronounce your last name for me, please?
Whirl.
Whirl.
Yeah.
Of course, it should have been much easier than I tried to do it. So thank you. It's Whirl.
Sorry.
All right. Last time we were here in November, you indicated that you wanted to represent yourself, and that you had some matters that you wanted to discuss with the prosecutor related to damages, I believe. And so, are you still wanting to represent yourself today?
Yes, Your Honor.
All right. Have you had an adequate opportunity to discuss matters with the prosecutor?
Yes, Your Honor, I did.
Is there a resolution of today's hearing or not?
There is, Judge.
And what's that?
It's a civil infraction for no proof of insurance. There was also a stipulation that she would pay restitution to the victim for the damages. However, we have not received any information regarding restitution, so I would just ask that that be set at 0 for now.
You would, if there's going to be anything in the future, you would bring that by a motion in the future?
I would.
All right. Ms. Worrell, is that your understanding of the agreement?
Yes, Your Honor.
All right. So a civil infraction would mean that the misdemeanor offense that you're charged with would be dismissed, and that you would then just pay fines and costs. No proof of insurance typically is a $160 ticket, and it does not have any effect on your criminal history. Do you understand all of that?
Yes, Your Honor.
There are, Mr. Fortier, there are actually 2 charged offenses, no insurance and failure to stop at the scene of a property damage accident. Are you indicating that both of those would be dismissed?
Yes.
All right. Is that what you understand as well, Ms. Worrell?
Yes, Your Honor.
All right. In order to take advantage of this plea to a civil infraction, you'd be giving up your right to have a trial and all of the things that would happen at a trial. Do you understand that?
Yes.
Let me go over those things quickly with you so that you can make an informed decision. At a trial, you'd have the right to be represented by an attorney if you wanted to. You could have a trial in front of a judge or a jury. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to remain silent and not have that silence used against you. You'd have the right to be presumed innocent until proven guilty beyond a reasonable doubt and have that burden of proof be on the prosecutor at all times. And you'd have the right to automatically appeal. All of those things would go away if you enter a civil infraction plea. Do you understand that?
Yes.
Has anybody, knowing all of that, do you still wish to enter your plea today?
I do.
All right, let me swear you in. So would you raise your right hand, please? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. The civil infraction of no proof of insurance would read as follows. It would say that on or about September the 14th of 2025 in Hayes Township of Otsego County, that you did operate a motor vehicle upon a public highway, and after being stopped by the police, you did not provide them with proper proof of insurance. Is that what happened?
Yes.
What vehicle were you operating at that time?
It was my truck that I just bought. It was a Ford F-150.
All right. And were you stopped by the police on that day? Or at
Yes.
least come into contact with the police?
Yes.
And you were not able to provide them with proper proof of insurance on that day, is that correct?
Correct.
All right. Have you provided, do you have proper insurance on the vehicle?
I do. I did take a copy to the prosecutor's office a couple weeks ago.
All right, great. All right, I do find that you've given me a proper factual basis as to the civil infraction of no proof of insurance, and I will accept your plea on that. Let me just make some notes on my paperwork. All right, the standard fines and costs on no proof of insurance is $160. Can you pay that within the next 30 days?
Yes, Your Honor.
All right, let me give you the number to call for the court to set that payment up. 731-0201.
Okay.
Go ahead and make that payment. That'll be all. And the case will be over with unless the prosecutor in the future finds out that there is some restitution amount, and that will he will be allowed to reopen the case just for that restitution issue. You understand that?
Yes, Your Honor.
All right. I'm just making a note that the prosecutor can reopen the case in the future if restitution. Now, I would expect that he will contact you ahead of time and tell you what the restitution amount is. And if you pay that, then we would not have to have a court case about it. But if he's not able to get a hold of you, or you disagree somehow with the amount that he's saying that it should be, then we'll have a hearing on that. Does that make sense to you?
Yes, Your Honor.
All right, that's all for today. Then if you take care of that within the next 30 days, that should take care of everything. Thank you, ma'am.
Thank you. Merry Christmas.
Merry Christmas. State of Michigan versus Anthony Pina, file 25-44055-ST. Mr. Pina with us?
Yes, Your Honor. It won't let me. There it goes.
All right, I do see Mr. Pina is with us. Mr. Fortier, is there a resolution of this matter?
Judge, I don't see where we've had contact with him. It looks
I have
like
notes. Yeah, I have notes that indicate we had a pretrial back on 11/26, I believe, and that the defendant was to call the prosecutor's office at that time. He was out in Washington State. And was supposed to call you on December the 10th. Mr. Pina, did that happen?
No, Your Honor, it has not happened.
What happened?
I've been extremely busy. My sister had a stroke back in October, so all of my time has been dealing with that. It's no excuse. I just missed the date to call them, so I just plan to plead guilty.
Well, I can let you talk to the prosecutor, see if there's a way to resolve it other than to plead straight up. If you'd like to do that, you can plead straight up if you wish. It's up to you.
The only thing I was worried about, because I have my commercial driver's license, is if that would be affected, but it's all non-moving violations. So I don't think it will have an effect. I think it's just money, just fines, I believe.
Well, it probably means in normal things it is just money, because there are fines associated with it, but these are misdemeanor matters, and I can't advise you on what impact that will have on your commercial driver's license. I simply don't know that at the moment. And and it's also, there are potential, I'm not saying I'm going to, but these do have the potential for jail time. These are misdemeanor matters that have 90 days and or $100 fines attached to all of them. One of them, count 3, has a $500 fine. So I want you to be aware of those things when you're making decisions. If you want to have an opportunity to talk with the prosecutor, certainly will grant you that. I'm not going to give you any more time after today, but I'm willing to give you one more shot at it if you'd like. However, you have the right to plead guilty to what you're charged with if that's what you want to do. So how would you like to proceed today?
Today, I'd like to just plead guilty. I don't want to take any more time of the court, or I'm still dealing with things up here in Washington. So I'd just like to, whatever it may be, I can come back to Michigan if there's jail time or whatever I need to do. I'll just plead guilty today.
All right.
Judge, real quick, what I can do for him today, I can't do anything with respect to count 1 or count 3, given the nature of the actual charges, but count 2, operating an unregistered vehicle, I can dismiss that one.
All right, that'll save you a little bit of money and heartache there, Mr. Pina. So dismiss count 2. Prosecutor's office's offers plead to counts 1 and 3. Is that what you want to do, Mr. Pina?
Yes, Your Honor.
All right. In order to do that, you'd be giving up your right to have a trial on all of those charges. And you'd also be giving up your right to all of the things that go along with a trial. So let me explain all of those things. At a trial, you'd have the right to be represented by an attorney. You'd have the right to have a trial before a judge or a jury. You'd have the right to see, hear, and question all the witnesses against you. You'd have the right to get a subpoena to require witnesses to appear and testify on your behalf. You could also testify, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. You'd have the right to be at a trial. You'd have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. finally at a trial, you'd have the right to automatically appeal. However, if you enter a plea, you'd be giving up that right and you'd have to ask for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, sir.
All right. Knowing all of that, do you still wish to enter your plea today?
Yes, Your Honor.
All right. I'm going to take some testimony from you, so I have to swear you in. Would you raise your right hand, please? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. Go ahead and put your hand down, sir. Has anybody promised you anything other than this plea agreement to get you to plead today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
All right. The charge in count 1 is called a Motor Carrier Act fuel tax violation. And it says that on or about May the 19th of 2025 in Chester Township of Otsego County in Michigan, that you did refuse or neglect to make a statement or return as required by the Motor Carrier Fuel Tax Act. Is that what happened?
Yes, sir.
Can you tell me what was the statement that you were supposed to make that you didn't?
I'm not quite sure. I just know that there's a tax that was supposed to be paid to operate the truck in Michigan.
And it wasn't paid?
No, sir.
All right. All right. And then as to count 3, it says at that same date, time, and place that you did commit Motor Carrier Act interstate registration violations and that you did engage in interstate transportation of property for compensation without registering with the Michigan Public Service Commission. That sounds like you were supposed to register and maybe pay a fee for over-the-road trucking for interstate commerce. Is that correct?
Yes, sir.
And did you fail to do that properly as well in Michigan?
Yes, sir.
All right. I do find that you've given me a proper factual basis as to counts 1 and 3 by admitting that you did not pay the proper fuel tax and you did not properly register under the Michigan Public Service Commission while engaging in interstate commerce and transportation of property. And I believe you give me that plea knowingly, intelligently, and voluntarily based on your answers to my questions. So I will accept your plea as to both of those. Give me just a second to catch up on my paperwork. All right. Mr. Fortier, do you have anything to add by way of allocution?
Judge, I just think based on the nature of the 2 offenses that were pled to, I believe fines and costs would be more than appropriate as a penalty for this one.
All right. Mr. Pina, is there anything that you want me to be aware of in before I impose sentence?
Yes, sir. I was just I was up there working. We were contracted under the power company Greater Lakes to doing storm work cleaning up the power lines. As far as that goes, having my CDL, I've constantly learned new things. So this is one that I had no idea about, the IFTA taxes. Beyond that, whatever the court decides, I accept.
All right. Sounds to me like this was a administrative issue as opposed to trying to do something wrong. So I'm just going to do the minimum fines and costs. As to count 1, it's the motor carrier fuel tax. There's a mandatory crime victim fee of $75, a justice assessment of $50. Excuse me. Court costs of $50 and a fine of $50. As to count 2, excuse me, count 3. Count 2 is going to be dismissed. That's the Motor Carrier Act interstate registration. There's a court costs of $50 and a fine of $50 as well. So that's a total of $325. Can you pay that within 30 days?
Yes, Your Honor.
Let me give you a number where you can call the court to set up that payment. The area code is 989. The number is 731-0201. And if you do that within 30 days, I don't have to add any fines or fees to that, and that will be the end of the matter. Any questions for me, sir?
No, sir.
You have a Merry Christmas. Good luck to you, sir.
You as well. I appreciate it. Thank you.
State of Michigan versus Adam Lonacek, file 25-44060-ST. Mr. Lonacek with us?
Ask him to unmute and start his video.
Yes, I'm here.
All right, Mr. Lonacek, I have a note on my file that says we tried to send correspondence out to you of today's hearing. And it was returned to us, unable to forward, a return to sender. What address do you want us to use to send documentation to you?
412 West Main.
That in Gaylord?
Yes, sir. That's Unit B as well.
All right, I've made note of that, and so is my staff. The charge against you is driving with license suspended. Have you had a chance to speak with the prosecutor about that?
No, Your Honor.
I think that might be a good idea so that you know what to do about it and how to resolve that matter. Mr. Fortier, is there going to be somebody in your office tomorrow or between the holiday?
I'll be here Friday if he wants to reach out to me Friday.
All right. What's the number that he should call in at, Mr. Fortier?
Just our normal office line, 731-7430.
Okay.
And you're going to ask to speak to Mr. Fortier on a pretrial conference so he can tell you what, if anything, you can do to resolve this matter. And then if you have any legal questions about the procedure, he can't act as your attorney, but he can tell you about the legal procedures of the case. And then you can decide what you want to do. We still have time on January 2nd.
We do. We'll do it in the afternoon.
All right. So I'm going to have you come back on a Zoom call like today on January the 2nd.
Okay.
At 1:45 in the afternoon.
Okay.
You have any questions about that, sir?
No, sir.
All right. So call Mr. Fortier on Friday, which is the 26th, at that number that he gave you, and have your pretrial conference, and I'll see you back here on January the 2nd, which will be the week after that. All right, sir?
Yes, sir. What time does the office open? 8 o'clock? Is that correct, or 9?
Mr. Fortier?
It opens at 8.
Okay,
but if you
perfect.
Call me at 9.
Okay, no problem.
All right. That's all for today then. Thank you.
Thank you.
State of Michigan versus Ann Wilson, file 25-44102-ST. Ms. Wilson with us?
Start her video.
All right, I do see Ms. Wilson is with us.
I'm here.
Ma'am, you're charged with operation without security. That means no insurance, but you're also failed to appear for a jury status conference on December the 3rd. What happened on December the 3rd that you weren't able to appear in court?
I was there, but then I had an appointment, so I had to leave.
Did you contact the court
No, I
staff
did
and say
not.
that you had to go?
No, I did not.
All right. I think you can see, just like today, we've got lots of court cases, and it takes a little while to get through them. Because here we are 20 minutes after 12. We're just now getting to your case. So I apologize for that, but that is the way that the court works, and there isn't a whole lot else I can do about it. So, all right. I'm going to dismiss the failure to appear because you showed up today, but don't let it happen again. Have you spoken with the prosecutor about how to resolve this case?
No. I was just doing it on my own.
Yeah, that's fine. You can do it on your own, but you need to talk to the prosecutor about how to resolve this case. Mr. Fortier, do you want to do a pre-trial conference, or do you want to talk to her right now?
Judge, we can do the same thing on Friday if she calls in.
All right. So Ms. Wilson, on December the 26th, which is this coming Friday, you're going to call the prosecutor's office at 9 a.m. and talk to Mr. Fortier.
Okay.
His number is 731-7430. That's his office number. You'll just ask for him. If he's busy, they'll tell you what to do, either to call back or to be on hold for a minute, and then you'll speak to him, and then we'll have a second status conference like today on Zoom on January the 2nd at 1:45. Did you get all that?
Yep.
So call the prosecutor this coming Friday after the holidays on December the 26th at 9 a.m. And then we'll have a jury status conference January the 2nd at 1:45. And I'll see you then. All right?
All right.
Merry Christmas.
Merry Christmas.
Next case is the State of Michigan versus Craig Wilhelm, file 25-44106-ST, set for a status conference. Mr. Wilhelm with us?
Yes, I am here. If you can hear me, but
I can hear you, but you need to turn on your video.
yeah. Okay, there it goes now. It wouldn't let me. There it goes. It said the host had it disabled. It's on now.
All right. Thank you, sir.
Thank you.
Mr. Wilhelm, you're charged with operating without a security. That means no insurance, but you're also charged with failing to appear for a status conference on December the 3rd. What happened on December the 3rd?
I called the number, the 989-731-7430 at 9 a.m. sharp. Spoke with the secretary, explained to her why I was calling and all the information needed. And she said that she would put me through to one of the prosecutors if nobody answered, to leave a detailed message, and they would get back to me when they can because they were busy, understandably. So I did that, left a long detailed message with all my information, my phone number a couple of times, didn't hear back, called again the next week, and basically had the same situation. And then I received this show cause in the mail. So I just really want to sit down with the prosecutor and about this pretrial, and said that's all I've been trying to do.
All right.
I don't know if
Well,
it's possible for me to.
give you a chance. Yep. I'm going to give you one more chance to do that. I don't know if you've heard what we did with the last couple of cases.
Yes,
Mr.
that'd be
Fortier
great.
is going to be available on Friday, the 26th.
Perfect.
So we'll do what's called a pretrial conference, 12/26 at 9 a.m. There are two others that are also calling in that same time. So please be patient and call back if you don't get him immediately, but he will be there that date. And then we're going to have another one of these hearings in front of me on January the 2nd of 2026 at 1:45 p.m. so that you can tell me what it is that you've learned from the prosecutor at that time. Do you understand both of those things, sir?
Absolutely, and thank you.
All right. Merry Christmas. We'll see you then.
You as well. Thank you. Merry Christmas.
All right. And the last case on the morning docket is the State of Michigan versus Amaya Young.
Morning. Afternoon now.
Good to see you. Thank you for being patient. Looks like you were charged with a license suspended or revoked or denied. Have you had
Yes.
opportunity to speak with the prosecutor about that?
Yes.
All right. And have you worked out an agreement with him?
No, I just think that I'm just gonna plead guilty. I don't have my license. That's all he asked me was, did I have my license back?
Are you going to be able to get your license back?
No, this ticket pushed me to 2030, so I am not able to.
All right. So you have the right to have a trial if you wish on whether or not you committed this offense. If you don't want to have a trial, you can certainly plead guilty, but I want you to understand what you're doing. So you'd be giving up all of your trial rights. Do you understand that?
I understand.
All right. Let me tell you what they are in a little bit of detail so you can make an informed decision. If you wanted to have a trial, you'd have the right to have a trial in front of a judge or a jury. You'd have the right to have an attorney represent you at that trial. You'd have the right to see, hear, and question all the witnesses at trial. You'd have the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. At a trial, you could also testify, or you could remain silent. And if you chose to remain
Good afternoon. Would you be Mr. Moore?
Yes.
Now calling case numbers 25S00519, 25T00080, also calling 09W191036A, and 24W002756. These are the matters of Reginald Moore. Appearances for the record, please.
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Moore.
Thank you. Mr. Moore, state your name for the record, please.
There's no more.
Okay, thank you. And Attorney Bukovich, did you have the opportunity to go over the charges with your client?
Yes, I did for the 25S and 25 Township cases. Are the 24W and the 25W cases misdemeanors or traffic stuff?
So the 2024 ticket and the 2009 ticket are just show cause hearings. He owes money on those.
Okay, I just want to make sure that.
Yeah.
So we were able to go over all charges, so we would be able to formal reading in both cases.
Okay, thank you. So, Mr. Moore, you have the right to remain silent. Anything that you say out loud or in writing can be used against you in court. You have the right to be presumed innocent beyond a reasonable doubt. You have the right to a trial by judge or by jury. You have the right to be represented by an attorney during all stages of these court proceedings, that is before, during, and after trial. You are not required to disclose citizenship status to the court, but you do have the right to consult with an attorney to see if these cases would have any effect on your citizenship status. If that last part doesn't apply to you, don't worry about it. Do you have any questions about your rights?
No.
Okay. So, Attorney Bukovich, do you want to address bond, please?
Yes, Your Honor, and we'll be standing mute to the charges in both cases. In addressing bond, Your Honor, I'll be requesting a personal reconnaissance bond in both matters. In the 25T0080 case, that is a driving while license suspended, so it's a non-violent traffic offense. So I believe a PR bond is appropriate there. In addressing the 25S case, Mr. Moore does have full-time gainful employment. He does work as a cook in Auburn Hills. He does have an alternate address that he could reside at. whether it be with his father in Ypsilanti, or he could always also find a hotel room. So there'll be no issues with a no-go to order to the address on the complaint. The only request we would have there is obviously a civil standby to allow him to pick up any items he needs for work. There would be no issue with no contact if the court does order. However, due to the time of year, I would, and the alleged complaining witness and Mr. Moore having a child in common who is less than a year of age, I would like to either request consensual contact or at least third-party contact, so my client will be able to see his baby for the holiday. But my client would have no other issues with any other orders of the court, and he did see the magistrate on some other past matters and received the PR bond on all matters, so there'd be nothing holding him.
How old's the baby?
11 months. 11 months, yeah.
So for both of these matters, the court will set a pretrial conference date that will be January 5th, 2026. That will be at 9 in the morning in person at the 14B District Court in Courtroom 1. For the driving while license suspended and operating without security matter ending in 080, the court's setting a personal recognizance bond. For the matter ending in 0519, the court will set bond with the following conditions. You are not to use or possess alcohol, marijuana, or illegal drugs. Within 24 hours of your release, you are to report to community corrections for drug and alcohol testing. You will need $12 and a photo ID. Prior to your release, you're to be fitted with a SoberLink device. That's something that you will take with you. You'll breathe into it a couple times a day and it will test you for alcohol. You are not to purchase or possess any firearms, ammunition, other dangerous weapons, or the means to create them. Any weapons that you do possess are to be surrendered. You are not to leave the state of Michigan without the court's permission. You are not to have contact with Brittany Mahoney. When the court says no contact, what the court means is no in-person contact, no contact through the mail, no contact over the computer or phone via phone calls, text messages, email, social media, the internet in any way, shape, or form. You may have consensual third-party contact for the purposes of childcare. So what that means is if somebody is going to pick up the baby, you don't go with them. You are not to go to Ms. Mahone's address, that being the Dorset Avenue address. When the court says do not go, the court does not care if you own a place, rent a place, or are personally invited to go to a place. Do not go. If you have things that you have to pick up from there, you may do that on a civil standby. It sounds like the public defender explained that to you already. You are not to engage in any sort of assaultive, threatening, harassing, terrorizing, molesting, or stalking behaviors towards Brittany Mahoney or anyone else. You are not to engage in any sort of criminal activity whatsoever. You are to appear for any and all dates set for you by the court. The next one in this matter, as I said, being January 5th at 9 a.m. at 14B. Because this case has a potential maximum penalty of more than 92 days in jail, you're also required to have your fingerprints taken. So you will get a signed fingerprint order and instructions in the mail with your next notice of hearing. Do you understand all of these bond conditions?
Yes. Is my mail going to the Dorset address or the Cliff address?
I put the Cliff address on the form for the court, so it should be going to that address.
Okay, just making sure. Just want to make sure.
Okay, yes. And at least as far as the notice to appear goes, if we've got a good phone number for you and it looks like Attorney Bukovich gave us one, you'll get text message reminders for the court date too.
Okay, cool. All right.
Also, you are to appear for any and all dates set for you by the court. Like I said, January 5th. That also means going to community corrections as directed.
Okay.
All right. So these conditions will be entered into the Law Enforcement Information Network. They will be readily accessible to any police officers that you may come into contact with. If they have probable cause to believe that you have violated one of these conditions, they can arrest you on the spot, and you'll be held for a bond violation hearing date in front of a judge who may revoke your bond and set a new, more restrictive one. For this matter ending in 0519, the court will set a $10,000 personal recognizance bond. So what that means is you are not paying anything to get out. Basically, you are promising to appear for your next court date and to abide by all of the bond conditions. If you fail to appear or violate any bond conditions, then a bench warrant may issue for your arrest. Your bond could be revoked entirely. At a minimum, it would start at $10,000. Any questions about anything I just said?
No.
Okay. Attorney Bukovich, did you have anything that you wanted to add?
Nothing from the defense, Your Honor.
Okay, thank you. And if you give me a moment, then I can look up what the balance is on those two older tickets so that you are aware. So it looks like the balance on the two tickets is $426 altogether. So I am going to set those for the January 5th date as well, just to keep your matters together. All right? Okay. All right. If you don't have any questions, then you are free to go to the door and tell the jail that you're finished.
Thank you.
Thank you. And I believe that concludes our docket for this morning.
Yes, Your Honor. Thank you.
Thank you.
One
Any
moment, Your Honor.
objection?
Your Honor, the state does acknowledge that pursuant to page 2 of the affidavit, the alleged occurrence date appears to be in March of 2023. However, the affidavit does appear to go on and allege that someone was injured after someone was playing around with a gun. That's quoting directly from page 2 of the affidavit. So the state does respectfully submit that a no contact order under these circumstances is appropriate.
Well, I'm going to specifically order no possession of firearms or dangerous weapons, no alcohol in any, don't be around it, don't drink it, don't consume it, don't purchase it. It can't be in the house if you're going to be in the house with your mother. And I am going to say no contact with your mother that isn't peaceful, but don't be having any alcohol or firearms anywhere around you. Do you understand that, Mr. Small?
Yes, ma'am.
I'll let you continue to live with your mother as long as you can be peaceful with her and have no firearms and no alcohol of any shape or form. And I'm only allowing this contact because you live with her and have apparently, as Mr. Patterson said, for about, well, since March of 2023, and they just now got around to filing it, so it must not be too dangerous. All right, so that's my order, and you must be back here. Did we give you your date? We did, didn't we?
Yes, Judge, March 2nd.
Yes, March 2nd. All right, you may go, sir.
Thank you, Your Honor.
You're welcome.
Thank you.
Shauna Thames.
Okay.
Hello. Hi.
We are on the record in BU 2025 TR 1543, State of Kansas versus Shauna Lee Thames. Jared Regier for the state, Darren Patterson for the defendant, who also appears in person on one count of seatbelt violation and one insurance violation. Mr. Patterson?
Judge, this is a case where I've only spoke to Miss Thanes this morning for the first time. Based upon that, she is charged with, as court noted, not having liability insurance, but she tells me that she does. She just didn't remember the date of the occurrence, so now I've given that to her. She's going to find that proof of insurance. Would ask the court to allow it to be severed one additional time for that purpose.
Jen, do we still have time on March 2nd?
Yes, Your Honor.
Mr. Regier, any objection to setting this over to March 2nd at the defendant's request?
No objection, Your Honor, if the court is likewise continuing the bond in this matter.
Mr. Patterson, Ms. Thames, this is continued at the March 2nd, 8 a.m. or whatever time Mr. Patterson wants his client here. And the bond is continued at $1,000, all posted conditions to continue. Nothing further. We'll be in recess. Ms. Thames is excused from today's proceedings.
And Judge, she was going to come across the street to my office to pick up a copy of the citation to make sure she has the dates. So, ma'am, my staff leaves in 15 minutes, so come right over.
Okay, thank you.
That
Thank
is
you,
the
Your
order of
Honor.
the court. Thank you.
The next one up.